of the District of Columbia Board of Ethics and Government Accountability to order. I'm Norma Hutcheson. I'm the chairperson of Bega, and this meeting is being held virtually via WebEx. Joining me today for this meeting are board members Charles Nottingham, Felice Smith, and Melissa Tucker. Board member Darren Sobin is not able to attend today's meeting. Together, we constitute a quorum for this meeting. Since it was first posted, the meeting agenda has not been changed in any way. So I ask the board members here to please take a minute to review the agenda, and then I'll entertain a motion to adopt the agenda.
Chair Hutcheson, I just wanted to note that it does not look like board member Smith is currently on. There are 3 board members there, so there are enough members for a quorum, but board member Smith does not appear to be on the meeting right now.
She just joined.
Oh, she just joined. Perfect.
She just joined. Okay, perfect. Okay. So as I said, we need a motion to adopt the agenda.
I'll offer the motion that we approve the minutes for today's.
Okay, well, we're at the agenda right now.
Excuse me, the agenda for today's meeting.
Okay.
I'll second that.
Okay, it's been moved and seconded that we adopt the agenda for today's meeting. All in favor, please indicate by saying aye.
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 There are no nays. Hearing none, the agenda for today's meeting is adopted. Next, we'll approve the minutes. This is from our September 14th meeting. The draft minutes were circulated in advance, and I ask that you take a minute to review those, and then we need a motion to approve the minutes from September.
I'll offer the motion that we approve the minutes from our September meeting.
Thank you. Is there a second?
I'll second that.
Okay, it's been moved and seconded that we approve the minutes from the September 14th meeting. All in favor, please indicate by saying aye.
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 Okay, are there any nays? Hearing none, the minutes from September are approved. Next on the agenda is a report from the Office of Open Government. We have Director Niquelle Allen, who will appear virtually on behalf of the office. And I ask Director Allen, please go ahead with your report. Thank you.
Thank you. Good afternoon, Chairperson Hutcheson and members of the board. I am Niquelle Allen, Director of Open Government. I am pleased to present this report on the activities of the Office of Open Government, or OOG. Since the last board meeting, OOG has continued to fulfill its mission of ensuring that all persons receive full and complete information regarding the affairs of the District of Columbia government and the actions of those who represent them. I will begin with Open Meetings Act and Freedom of Information Act advice rendered by the Office of Open Government. Advisory opinions are first. Since the last board meeting, OOG issued 2 advisory opinions on the implementation of DC FOIA. The first opinion regards the Metropolitan Police Department's release of police disciplinary records. On September 22nd, 2023, the Office of Open Government issued advisory opinion number OOG-2023-003AO regarding MPD's compliance with DC FOIA. In this matter, MPD issued a justification for its denial of police disciplinary records to a requester that inaccurately described the relevant statute concerning the implementation of the requirement to release these records. OOG advised that MPD did not apply the inaccurate language in the analysis to deny the request for disciplinary records. Thus, MPD's response complied with DC FOIA. A copy of the version published on open-dc.gov is in Dropbox. The next matter is MPD's release and redaction of body-worn camera recordings. On September 15th, 2023, OOG issued advisory opinion number OOG-2023-002AO regarding MPD's compliance with DC FOIA. This matter concerned an individual's request for certain body-worn camera footage from MPD. MPD had released a partially redacted recording using Exemption 2, which is found in DC Official Code Section 2-534A2, which is permitting withholding where public disclosure would constitute a clearly unwarranted invasion of personal privacy, to partially redact the video and audio recording, including faces, officers' badges, and an interview of possible witnesses/driver. OOG advised that 1, MPD incorrectly applied Exemption 2 to redact the faces or badge numbers of on-duty officers in uniform, since the officers did not have an expectation of privacy under these circumstances. And 2, MPD correctly applied Exemption 2 and redacted the faces of any third-party passersby and the driver's statement because the requester did not offer to OOG and OOG did not find a public interest in disclosure to outweigh the privacy interests. A copy of the version published on open-dc.gov is in Dropbox. The next matter are our informal OMA and FOIA advice rendered by the office. Since the last board meeting, OOG has responded informally via email or telephone to requests for assistance as follows. OOG responded to 1 request for Open Meetings Act advice. OOG responded to 8 requests for FOIA advice, and OOG responded to 12 requests for technical assistance with open-dc.gov. The next item is remote meeting monitoring. OOG attorneys attend remote public meetings to ensure compliance with the Open Meetings Act and inspect public body websites and OOG's central meeting calendar for public meeting notices and records. We provide legal advice on the Open Meeting Act compliance and take corrective action if necessary. During September 2023, OOG's legal staff attended 37 remote public body meetings. As a result of the monitoring, 4 instances of written corrective measures were taken. The public bodies failed to do the following: 1, post meeting agendas; 2, post meeting agendas timely; and 3, provide access to meetings. The next item in my report are training and outreach. First is the ASAP FOIA and privacy training. That's the American Society of Access Professionals. On September 5th through 8th, 2023, Attorney DeBerry attended the ASAP FOIA privacy training in Minneapolis, Minnesota. The training covered customer service, Privacy Act disclosure issues, FOIA exemptions, and drafting FOIA documents. The next item is the Missouri Bar Annual Meeting. On September 14th and 15th, 2023, Attorney Weil attended the Missouri Bar Annual Meeting. The meeting presented continual legal education programs, including insights and perspectives on best practices at trial and pitfalls to avoid in the courtroom, tips and strategies for effective brief writing and oral argument, ethics in mediation, ethics unveiled, navigating social media in the legal realm, and from facts to fiction, the art of storytelling in legal persuasion. The next item is Future of Work, a new innovation playbook seminar by the Washington Post. On Thursday, September 21st, 2023, I attended the Washington Post live event, The Future of Work, a new innovation playbook seminar. Representative Ted Lieu of California, member of the bipartisan Congressional AI Caucus, Christian Janser, SLAC's Senior Vice President of Research and Analytics, and Michael Crow, President of Arizona State University, presented and received questions from reporters in the audience. The topics discussed were artificial intelligence and its impact on jobs and education, and the best approaches to teleworking. The next item is Train the Trainer training. On September 22nd, 2023, attorneys Weil and Skirbo attended part 2 of Train the Trainer training conducted by Alex Kipp, Director of Education and Engagement for New York City's Conflict of Interest Board. This training introduced participants to presentation fundamentals, including vocal dynamics, audience engagement, and techniques for presenting online. The next item is Supreme Court term review. On September 29th, 2023, OAGs, the Office of the Attorney General, Solicitor General Caroline Van Zyl, and Principal Deputy Solicitor Ashwin Pathak facilitated the Supreme Court term review and preview. Attorney DeBerry, Attorney Weil, Attorney Skirbo, Paralegal Brown, and myself attended the presentation. The training provided an update of recent decisions issued by the Supreme Court and an overview of cases pending in the upcoming term. And the last item is the Digging in DC event with the DC Open Government Coalition. On Saturday, September 30th, 2023, Attorney Skirbo presented on accessing public records and the Freedom of Information Act at the Digging in DC event with the DC Open Government Coalition. Attorney DeBerry and Attorney Weil attended the event, which took place at the Anacostia Neighborhood Library. The next item in my report is the litigation and legislative update. The litigation report is first. The first case is Dubose versus District of Columbia. This case was remanded for consideration of the merits of the denial of fee waiver and reasonableness of fees. I have previously reported on this case, and a 3-judge division of the DC Court of Appeals has now handed down its opinion. The appellant, Dr. Dubose, requested copies of all the decisions that the Board of Dentistry renders against licensed DC dentists since 2010. He also requested a list of experts hired by the Board of Dentistry in connection with those decisions. He requested all decisions by current members of the board since their appointment, all complaints against DC dentists settled confidentially or dismissed since 2010, the resumes of the current Board of Dentistry members, and all appeals of the Board of Dentistry's decisions since 2010. He also requested waiver of fees. DC Health untimely responded to the FOIA request on behalf of the Board of Dentistry and declined to waive fees and demanded $9,000 in advance fees for the estimated cost of the search and review. DC Superior Court granted summary judgment in substantial part, and Dr. Dubose appealed. First, the appellant judges disagreed with Dr. Dubose's argument that the untimeliness entitled him to a fee waiver per se. The appellate court acknowledged that the federal FOIA does provide for waiver of fees when the agency was delinquent in its response. However, DC FOIA does not contain that provision. Although courts generally look to federal FOIA in interpreting DC FOIA, that principle does not apply where the two acts differ, as in this case. Next, the district argued that Dr. Dubose could not challenge the demand of prepayment of fees unless he actually paid such fees, i.e. that he instead should have appealed to the mayor's office of legal counsel. Otherwise, he has not exhausted administrative remedies. The parties disagreed about whether the public body has unreviewable discretion to deny a fee waiver because of the word may in Section 202 of DC FOIA. The judges disagreed with the general principle, i.e. the Court of Appeals could not potentially vacate an agency or public body's fee decisions, but first they are remanded to the Superior Court for first-level review of the fee waiver and fee amount. The appellate panel did, however, list several factors and questions that the Superior Court may review in its analysis. These are the standard of review, who bears the burden of proof on whether the waiver would be in the public interest, what materials may properly be considered by the trial court in reviewing an agency's waiver determination, Dr. Dubose's claim that his request was in the public interest rather than for a commercial purpose, prior fee waiver decisions by the board, DC Health, and other district agencies, Dr. Dubose's claim that considerable portions of the requested records were easily accessible and therefore did not require significant resources, Dr. Dubose's argument that no fee should be imposed for the records that must be uploaded proactively, Dr. Dubose's claim that the board was required to provide him with information that would permit Dr. Dubose to reduce the fee by narrowing the categories of document, and Dr. Dubose's argument that the district acted in bad faith. The opinion is in Dropbox. The second case is Tax Analyst versus District of Columbia. This case was remanded for an in-camera review of private letter rulings. As I previously reported, Tax Analyst, a publisher of tax journals, and reporter Aaron Davis both sued the District of Columbia under DC FOIA after the Office of Tax and Revenue, OTR, denied their request for 24 private letter rulings, or PLRs. PLRs respond to circumstances and data submitted by particular taxpayers, but the advice given in them has broader applicability, so the requester appellants argued that OTR must still release them after redacting specific details that would identify the underlying taxpayers. DC Official Code Section 47-4406A provides, and I quote, an officer, employee, or contractor or former officer, employee, contractor of the District of Columbia shall not divulge or make known in any manner federal, state, or local tax information either submitted by the taxpayer or otherwise obtained, end quote. The District of Columbia argued that this statute supersedes DC FOIA because one, it is more specific, and two, the PLRs in question would contain such tax information that even if it could be partially redacted, would leave the requested rulings with no informational value. On July 27, 2023, the District of Columbia Court of Appeals handed down its opinion and agreed with OTR that there's no question that DC Official Code Section 47-4406 is a, quote, other statute to which Exemption 6 defers, and PLR potentially falls under this statute. Comparing Section 47-4406 to the corresponding federal tax provision, the judges reasoned that because PLRs may contain data furnished by taxpayers with respect to the determination of the existence or possible existence of liabilities, PLR may contain return information and therefore tax information. However, the panel ultimately held that the Superior Court erred in granting summary judgment to the district without first examining the PLRs in camera to determine whether any non-exempt portions of the documents were reasonably severable from the tax-exempt information such that the PLR should be disclosed in redacted form. The judgment was reversed and remanded for further consideration by the Superior Court. The slip opinion, judgment, and Superior Court reassignment and scheduling order are in Dropbox. OOG will continue to monitor the proceedings on remand. The last case is the Washington Post lawsuit regarding police officers' disciplinary records. On June 3rd, 2023, the Washington Post legal entity, WP Company LLC, quote, the Post, appealed the Metropolitan Police Department's denial of a reporter's request for certain disciplinary records to the Mayor's Office of Legal Counsel, or the MOLC. The MOLC affirmed MPD's denial of the request, and on February 14th, 2023, the Post filed a complaint in DC Superior Court for judicial review under DC FOIA. DC filed its answer on April 28, 2023, including 12 numbered defenses, including that the Post FOIA requests are unduly burdensome. Note that MPD relied on exemptions 2, personal privacy, and 3C, law enforcement, in its denial. On September 14, 2023, the Superior Court awarded summary judgment to the Post. The court balanced the public and privacy interests with respect to the question and concluded that they favored disclosure. MPD was required to produce the records by September 29, 2023, and the Post was allowed to move for fees and costs by September 29, 2023. The complaint, answer, cross motions, and order are in Dropbox. Next is the report on legislation. Advisory Neighborhood Commission's Remote Operations Emergency Temporary Amendment Acts of 2023. That's DC Act number 25-191, Bill number 25-362. Although the Advisory Neighborhood Commissions are exempt from the Open Meetings Act, I am noting this legislation to show the Council's support of remote attendance. These bills extend the pandemic-era amendment to the Advisory Neighborhood Commissions Act of 1975 that provides that 1, commissions may meet and commissioners may appear and vote without being physically present through a teleconference or through digital means identified by the commission for this purpose, and 2, members present count towards quorum whether they appear physically or remotely. The Emergency Act is set to expire on October 24th, 2023. The temporary bill passed on first reading on September 19th, 2023. The bills are in Dropbox. The last item in my report are administrative matters. The first is Chief Counsel position vacancy. Bega is currently soliciting applications for the position of Chief Counsel of the Office of Open Government. The position will be posted on internal and external recruiting websites until October 8th, 2023. The last item is Bega's office relocation. The Bega team continued weekly meetings with the Department of General Services and its contractors regarding the agency's relocation to 1030 15th Street Northwest. Myself, Director Cooks, Chief of Staff Mitchell, and IT Specialist Brown met with DGS project managers and the construction team to discuss the progress of the agency's relocation to its new facility. The projected date of the relocation move is still mid-November 2023. Chief of Staff Mitchell is coordinating the agency's move, and Director Cooks will provide additional details in her report. This concludes the Office of Open Government's October report. I am happy to answer any questions the board may have at this time.
Thank you, Director Cooks. Are there any questions for Director Cooks?
Director Allen, thought was.
I'm sorry, Director Allen. Director
We're both
Cooks is
wearing
here.
green today.
Yes. Director Allen, are there any questions for Director Allen?
Madam Chair, I have a question on the very first item you mentioned, Director Allen, and thank you. That was a very comprehensive and good report. You gave a little overview of the MPD FOIA response compliance, and I want to make sure I heard it correctly. There was some question as to whether MPD had properly articulated its reasons for responding to a FOIA request the way that it did. And then upon further examination, it was determined that the rationale, the justification was actually there in the background. And so it was the FOIA, the information was in the end appropriately handled or withheld. Help me understand though, do we ask an agency, in this case MPD, to go back and send a correct letter? Because it can be confusing for the public if they receive a letter that is, substandard or not responsive or not correct in its rationale, even when the agency was substantively doing the right thing for the right reason. But I do think as a former, I was a long time ago, I was a former trained U.S. Department of Justice FOIA officer. And in those days, we were always told it was real important to articulate in the letter back to the public the correct rationale for the FOIA determination. Can you give me a little bit more info on that?
Yeah, I agree with you. I think it would be a good idea if they did. And in this particular case, this was about the implementation of the law that requires them to release the police complaints. And they incorrectly recited the timing of the implementation of that law. So it didn't go directly to the analysis around the exemption. It had more to do with the Appropriations Act, so to speak, that led to the determination that they had to release the records in the first place. So that's where the analysis was incorrect. It wasn't germane to the actual release of the documents. So that part of their analysis we found was correct. I think it is a good idea for them to, as you say, provide a full, correct analysis, and we will go back. We didn't at the time. We just advised them as to what the correct recitation of the law would be, and told them what we did think they did right and what they did wrong. We didn't go as far as to say they should re-release a corrected letter, but I do think that is a good idea, and that's something that we can amend and send a follow-up with them to instruct them to do.
Thank you. I'd appreciate it. I think it just makes good sense, and it sort of treats the public the same way, the agencies the same way the public's treated. If a member of the public sends a letter with the right intentions and the right sort of thinking behind it, but the letter isn't written correctly, agencies are usually pretty quick to sort of dismiss those. And so I feel like this is sort of a nice fairness and parity, and also just good, clear, documentation of, what actually happened. So thanks for looking into that and seeing if you could address it. I appreciate that.
You're welcome.
Any other questions for Director Allen? Okay, thank you, Director Allen. We'll Move to the next item on our agenda, and that's the report from the Office of Government Ethics, also appearing via WebEx. Is Director Ashley Cooks, who will provide the report from that office.
Good afternoon, Chairperson Hutcheson and members of the board. I'm Ashley Cooks, the Director of Government Ethics. I'm pleased to present this report on the activities of the Office of Government Ethics, OGE. First is an update on the status of OGE operations. The information reported today regarding OGE's cases will not reflect any status changes that may occur because of actions taken by the board during today's meeting. First, open investigations by status. We have a grand total of 35 matters. For open undocketed matters, we only have 1. For pending state investigations by status, we have 35 matters that are closed pending collection, 3 matters stayed pending DC Superior Court case, 1 matter stayed for OAG False Claims Act case, 2 matters stayed for OIG investigation, and there are no matters stayed for U.S. District Court case for a grand total of 41 matters. For regulatory matters by status, we have 26 matters that are closed pending collection, 27 matters that are open for a grand total of 53 regulatory matters. Again, we currently have 35 open investigations and 6 matters that are stayed. The number of open preliminary and formal investigations includes 7 new matters. The investigative team resolved 8 investigations since the board last met. This total does not reflect the number of complaints that were dismissed for a lack of jurisdiction. Pursuant to the Board of Ethics and Government Accountability Delinquent Debt Recovery Amendment Act of 2022, Bega may discretionarily transfer delinquent debts associated with settlements and judgments for Ethics and Open Meeting Act violations to the Office of the Chief Financial Officer's Central Collection Unit, CCU, for collection. The Act requires that funds collected on Bega's behalf be deposited into the Ethics Fund or OMA Fund. OGE has finally received a fully executed Memorandum of Agreement for debt collection services with the CCU. This week, we began the process of transferring delinquent debts to the CCU for collection, starting with the 35 closed pending collection investigations I previously mentioned. Next is an update on trainings and outreach. First, professional development trainings attended by staff. September was once again a busy month for training for OGE. All OGE investigative staff attended the CMTS training to learn basic and advanced techniques in using our case management software. Following last month's meeting, investigators Ileana Corrales, Rhoda Glasgow, and Tasia Reed, as well as attorney advisors Fran Van and Marisa Jones, attended the National Institute for Trial Advocacy's Investigative Questioning Techniques program at American University, Washington College of Law. The hands-on course focused on admission seeking and theory testing. OGE attorneys and OOG attorneys Nick Weil and Anthony Scarborough attended part 2 of a 2-part series on Train the Trainer with Alex Kipp from the New York Conflict of Interest Board. This series was designed to help attorneys become more dynamic and engaging presenters, especially in terms of giving training. The last session had participants give presentations using the skills learned in the first session. Alex Kipp has been the Director of Education and Engagement at the New York Conflict of Interest Board for over 16 years. He has a diverse performance and theater background in addition to his ethics work. OGE reconnected with him at Kogel last December via his presentations. Program Support Assistant Naquita Titus and IT Specialist Kevin Brown attended the Quick Base Apathon sponsored by the Office of the Chief Technology Officer, OCTO. General Counsel Rashi Raj attended the Supreme Court Term Review and Preview training put on by the Office of the Attorney General last week prior to the start of the new term. For trainings conducted by staff, since the September board meeting, OGE has conducted 4 training courses, which included 2 DC-1 fund trainings, a lobbyist reporting and registration training, and a monthly brown bag session. On Monday, September 25th, Attorney Advisor Fran Van presented the September Ethics Council brown bag session on the DC-1 fund. 24 ethics counselors were in attendance and engaged in discussion about the ethical propriety of fundraising under the DC-1 fund. A copy of the presentation was placed in the Dropbox. During the month of September, 23 employees completed our online ethics training via PeopleSoft, and 7 users completed courses using our learning management system. The most completed training course this month on the LMS was BGA 919, General Boards and Commissions Training. For outreach, OGE is preparing for Ethics Week 2023. The week-long event will take place on October 23rd through the 27th, 2023. This year's theme is Ethics Every Day, #can't go a day without it. The coordination committee, led by Supervisor Stuart Mitchell, has finalized the agenda, scheduled speakers, and purchased memorabilia. In addition to new sessions, we are reviving sessions with perennial favorites, such as the Campaign Legal Center, guest speaker Michael Brett Hood from last year, and of course, the DC Bar for Legal Ethics for Government Attorneys. A final schedule was published on the website and placed in the Dropbox. For an update on the Bega newsletter, on Friday, August 18th, OGE published Volume 8, Issue 4 of its newsletter, Ethically Speaking. The newsletter provided financial disclosure statement fine information for non-filers, informed readers of the ethical issues within the 3 branches of the federal government, and included enforcement actions taken by the agency and other state ethics commissions. This issue is available on the Bega website. The next issue will be published on October 13th. Next is an update on advisory opinions and advice. First, informal advice. OGE's legal staff provided advice for approximately 33 ethics inquiries, which is 8 less than the 41 reported at the last board meeting. This number does not include responses we have provided to questions regarding the lobbyist and FPSE filing systems. For formal advisory opinions, on August 2nd, OGE issued an advisory opinion upon request by the Executive Director of the Poverty Commission regarding outside activity restrictions. The opinion addresses whether the director can serve as an adjunct professor at American University without the role conflicting with his government service. This opinion provides guidance on the conflict of interest statute and the outside activity restrictions. Based on the facts, there is no apparent conflict with the director's official duties and his potential employment as an adjunct professor. Therefore, the outside activity is permissible, but is still subject to the ethical restrictions. This opinion has been finalized and published on the Bega website. OGE is in the process of drafting an advisory opinion that addresses the obligations surrounding cooperating with ethics investigations and the prohibition on retaliation, as well as an advisory opinion on the use of official social media accounts opposed to the use of personal social media accounts. Next is an update on legislation. We only have one update, and that is the Comprehensive Code of Conduct. As defined in the Ethics Act, the Code of Conduct consists of 7 different statutes and regulations with variable applicability. The Comprehensive Code of Conduct, CCC, is legislation that consolidates the district's ethics laws and standardizes the ethical practices between the legislative and executive branches. OGE's legal team will again review and update the CCC with the goal of submitting an updated version of the legislation to the board and then the council. Next is an update on OGE administrative matters. First, OGE staffing. There are no updates on staffing since OGE is now fully staffed. For an update on the office relocation, our office relocation is still underway and we are approaching the finish line. OGE and OOG continue our weekly meetings with the Department of General Services and the project management team to discuss construction and technology needs for the boardroom and staff areas. According to the construction team, the ceilings have been closed and OCTO is in the process of completing technology installations. The construction is nearly completed and most of the furniture has been installed. On September 29th, IT specialist Kevin Brown visited the office and confirm the delivery of our 3 new Xerox machines. The proposed move-in date remains mid-November, but may take place sooner. Next is an update on financial disclosure statement, FDS. Pursuant to DC Official Code Sections 1-1162.24 and 1-1162.25, public officials and certain government employees must file a financial disclosure statement as a means of transparency and to prevent engaging in conduct that violates the Financial Conflict of Interest statute. Bega is responsible for ensuring that employees and public officials who meet the statutory requirement file their annual financial disclosure statement. The FDS team has identified designated filers who have not filed or were late in filing their statements. The affected persons received notice on August 7th that they were being assessed a fine. Of those recipients, several filed fine waivers requesting that the board waive the fines assessed. The FDS team has scrubbed the list for OPRS, removing those seeking waivers and those who have left district government. The month of October marks the beginning of council members' biannual financial disclosure. Attorney Advisor Fran Van and Program Specialist Kosick intend to notify the council members and their chiefs of staff of the requirements on August 13th, with the filing due by November 15th, 2023. Next is an update on lobbying registration and reporting, LRR. Pursuant to DC Official Code Section 1-1162.27A, a person who receives compensation or expends funds in an amount of $250 or more in any 3 consecutive calendar month period for lobbying shall register with the Director of Government Ethics and pay the required registration fee. According to DC Official Code Section 1-1162.30, each registrant shall file a quarterly report concerning the registrant's lobbying activity during the previous quarter. OGE sent fine letters to 3 separate entities for late activity reports in August. The 4th quarter activity reports are due on October 15th, and the LRR team sent notice to all registered lobbyists. On September 22nd, Octo deployed the LRR e-filing system enhancements. End users will see the following notable changes. Number 1, reporting entities will not be able to file activity reports without a current registration or if there is an outstanding fee or fine. Number 2, registrants will have to pay the registration fee before submitting a registration report. 3, when filing a termination report, the registrant will no longer have to manually deactivate a client. When certified, the termination report will automatically deactivate the relationship. This will eliminate delinquent notices to those who are no longer active. 4, there is now a clear difference between client, registrant, and lobbying entity. This has caused confusion on the reporting side for the LRR staff audits and review. Registrants and clients will now see how they are reported and can make the necessary changes if incorrect. And 5, the turnaround time for adding DC officials has been shortened by the LRR team's ability to designate and add the names as necessary. For the LRR team, the enhancements will allow for better tracking of contributions, fine payments, and fine assessments. All in all, these tools improve the LRR e-filing system and will allow the LRR team to provide better customer service in the months and years to come. As previously stated in the training section, on September 20th, Attorney Advisor Maurice Eccles and Program Coordinator Stan Kosick conducted a lobbyist reporting and registration training. And my last update is on public investigations. We only have one, that is 23-0006F, Henry David DeBoer. This is a formal investigation based on a complaint filed by the Criminal Justice Coordinating Council, CJCC, and referred by the Office of the Inspector General. According to the complaint, David DeBoer, respondent, former IT specialist with the Department of Employment Services, provided IT services to CJCC through a vendor, Enlighten Inc., during his government tour of duty. During this time, respondents submitted timesheets to DOES, which reflected his normal district government tour of duty from 8:30 to 5, Monday through Friday. Respondents' alleged conduct violates DPM Section 1807.1, which prohibits employees from using government time or resources for other than official business or government-approved or sponsored activities. Respondent also failed to report enlightened on his 2022 financial disclosure statement and failed to file a 2023 statement. OGE is in the process of serving the respondent with the notice of violation. Thank you. This concludes the Office of Government Ethics, October 5th, 2023 report.
Thank you, Director Cooks. Are there any questions for Director Cooks? Any questions at all? I want to encourage the board members to attend the Ethics Week. I think you said October 23rd through the 27th. Those are the right dates? Okay.
Yes.
And it looks like we're on schedule for moving into the new office space. Are there any plans for inviting the board down to see the new space?
Sure. We are planning a visit next week, and depending how things are looking, then we'll invite the board over.
Okay, or we can wait until after everything's the move's completed, just as long as we get to take a look at some point.
Okay, sounds good.
Okay. Sounds good. Okay. Next on the agenda are public comments, and the public was invited to submit comments in writing by 11 a.m. today, and no comments have been received by 11 a.m. The next item on the agenda is executive or closed session. Agenda item is a closed session to discuss ongoing confidential investigations and pursuant to DC Official Code 2-575B14, to consult with an attorney to obtain legal advice and to preserve the attorney-client privilege between an attorney and a public body pursuant to DC Official Code Section 2-575B4A, to discuss personnel matters, including the appointment, employment, assignment, promotion, performance evaluation, compensation, discipline, demotion, removal, or resignation of government appointees, employees, or officials pursuant to DC Official Code Section 2-575B10, to deliberate on a decision in which the Ethics Board will exercise quasi-judicial functions pursuant to DC Official Code Section 2-575B13, and to discuss contract negotiation strategies pursuant to DC Official Code Section 2-575B2. May I have a motion to enter into executive session?
I'll offer the motion that we enter into executive session.
There's a second? Thank you. It's been moved and seconded that we enter into executive session. All those in favor, please indicate by saying aye.
Aye. Aye.
Any nays? No. Okay, so the time is now 12:43 p.m. And I will ask that you log out of this session and log into the executive session. And if there are any matters to report out, we return to this to report out those matters and also to adjourn the meeting. Thank you. Okay, the time is now 12:56 p.m. and we are back on the record. In executive session, the board approved an amended notice of violation and order authorizing the service via email to respondent's personal email address in NRA in 23-0006-F, NRA D. DeBoer. And the board also approved a negotiated disposition in matter 23-0075-P, NRA R. Broadnex. Both votes were unanimous. This concludes the meeting of the DC Board of Government Ethics and Government Accountability. Our next meeting will take place remotely via WebEx on November 2nd, 2023 at 12 noon. Thank you. Have a good holiday. I think we have Indigenous Peoples Day coming up before we meet again. Thank you.
Thank you, Madam Chair.
Thank you.
Thank you.
Bye-bye.